we both know that I'm anxious to be in my children's lives, and I've fought since 2008 to be in my kids' lives. So I think I've been pretty straightforward. The sooner the better. Right now I'm getting no access to my kids. Just prior to this, I was
Ms Applegate
aware that I lost my driver's license and didn't step in any way to help me get my license back. And that I lost my license because I didn't have enough money to pay child support, but I also been to court 17 times to be part of my children's lives. And as you can imagine, that's expensive. And that's what put me behind. So what are you ask? What exactly are you asking?
Okay, so all I'm saying is that if you would like the hearing to be on Thursday, we could do that. If you need more time to look at my affidavit materials, we can do that as well. Like, we can either do it on Thursday if you so choose, or if you need more time, I would have no issue with giving you more time to do the week after or whatever works for you, basically.
You mean not go to court and not see my kids?
No, I mean, whatever. You can do it on Thursday, or you can do it the week after. However much time you need to go through the materials is what I'm saying. Because I don't want to put you in the position where you feel like you're rushed with respect to our materials and not have the ability.
Yeah, but I served
Ms Applegate
and you a number of months ago, and I still haven't got a response back from you and
Ms Applegate.
Yeah, well, that's what I'm saying. I'm going to be serving you this stuff today. I just wanted to have a chat with you before doing so, just to see what your timing was, because I haven't received a requisition from you to reschedule to the 16th, which is this Thursday.
Yeah.
I wanted to chat with you about the timing.
Well, I haven't even got a response. Am I wrong to say that you got 21 days once you've been served? You got 21 days to file a response?
No, well, that's with respect to a notice of civil claim and response to civil claim. So for a notice of civil claim, which is initiating a lawsuit against a party, if the party doesn't respond within 21 days, you can take default judgment. But this is an application response and a notice of application, so it's different.
Oh, is it? Oh, okay, because I noticed on the bottom of the form itself that I sent
Ms Applegate,
because I used the, let me see here, I actually got my computer open here, just one sec. Form 30, is it?
Mm-hmm.
So it says, I'm just going to open it up here. It says, that's the affidavit is Form 30, so it's 31. It's a notice of family civil claim. Yeah, Form 31, so I sent a notice of application to
Ms Applegate.
I wanted to change my access, right, because I haven't seen my kids because I'm living up country here now. Modify my access. That's what I asked me
Ms Applegate
to do. That was sent a number of months ago.
Yeah,
I still haven't got a response, but it says here, I'm reading time for response to application. The documents referred to in paragraph C above must be served in accordance with that paragraph. Unless one of the following paragraphs applies within 5 business days, that one not. If the applicant is Rule 11.3, it says here, C, if this application is brought to rescind, change, or suspend a final order within 14 days after service of this notice of application.
And the thing is, I was trying to work out a solution out of court between the two of you, so that's why there was a delay with respect to the service. But the materials are ready. I will be serving them on you today. And I just want to, if you want to go ahead on Thursday, let's go ahead on Thursday. If you need more time, I can give you more time. I just want to accommodate you to do whatever is most comfortable.
Andrew, you just glossed over that. That was completely, I know you're a lawyer, and I know I'm just a dad trying to protect my kids and trying to stay on my children's lives, so I'm not nearly as smart as you, Andrew Lau. But time for response on application, on my application, notice of application, it says here, time for response,
days, right?
14 days. Hold on.
You now, okay? You had to give 60 days statutory notice with respect to your move to Kamloops. You did not do that, and then you just filed and served these materials on my client unilaterally without canvassing us for dates. So then I was trying to work this out between the two of you so that you guys didn't have to go to court, so it'd be easier and amicable solution, okay? That didn't work out. Now my materials are ready. They're going to be served upon you. All I care about right now is if you want to go ahead on Thursday, we're going ahead on Thursday. You serve me with the requisition so that you can reschedule the date, and then we're going ahead, okay? That's the point of my call. I'm not here to argue with you about other stuff. I just want to stick to the issues. All right, Cliff?
Andrew Lau, again, you're the smart guy. You went to law school. I'm just asking you here.
About what? What are you asking me?
I served your client over 2 months ago, asking don't cut me off, please, Mr. Andrew.
This conversation is not going anywhere. You will get my materials later on today, and you can email me with respect to whatever your views are then, okay? Thanks. Bye.
Hello? So, I got a call from Andrew Lau. I served my ex-wife. I had originally asked her to modify my access about 6 months ago. Then I started writing it in emails about 4 months ago saying, can I modify my access? I'm moving up country. And I didn't hear anything, and I got the runaround. So about 2 months ago, I served her notice because I knew this was going to go on forever and to go to Supreme Court. And a notice of application, quite expensive, a lot of work. I want to see my kids. And she went to the courthouse, and she claimed to the judge she didn't have time to get a lawyer. So the judge said, okay,
Ms Applegate.
I believe you, and gave her some time to get a lawyer and to respond to my notice of application. She had 21 days, 21 working days. Nothing moved forward whatsoever. Now we're going on a couple months here now, and I just got a call from her lawyer that he wants to go to court. He's willing to go to court this Thursday. So that gives me, he knows I live out of town. I haven't even seen the response material, and they're way over the over the 14 days. So I got that wrong. It says here they have 14 business days after service of this notice of application, and it's been some months now, and he wants more time, as I guess he's calling up and playing games. So when I questioned him on that, he decided just to hang up on me. That is uncalled for, and I will be putting in another complaint to the BC. I'm just flustered. I didn't expect this call. It's actually a weekend too. It's a Sunday. He's calling me on a Sunday, telling me, just playing games with me. I haven't heard from him in weeks. I told him that yes, I want to go to court on the 16th, which is this Thursday, but I need to see your materials, and he didn't provide them. And now I get a call on Sunday that he's going to send me the materials, and he hasn't yet. So I suppose he's mad at me because he has to work now on the weekend, but still I wouldn't be able to go. How would I arrange this in such a short amount of time? And here we go, 6 months to change my access, hundreds and hundreds of dollars, trips back and forth to the New West Courthouse. I just want to modify my parenting time. That's all I want to do. I'm asking for no more time. I'm just asking that my time be switched around so I can access my kids. And this is the games, the absolute brutal games I go through. It's been since 2008, it's 2015 now. And I've been to court 17 times. Been to family court 17 times. I don't drink, don't smoke, I've never been violent, I have no criminal history, I've never even lashed out at anybody. There I when I question people, you get the passive aggressive. I got the hang up from Andrew Lau, the owner of Andrew Lau Law Firm. 17 times been to court. to have access to my own children, my own flesh and blood, 17 times, tens and tens and tens and tens of thousands of dollars. Just complete abuse of the system, absolute complete abuse. And that Andrew Lau facilitates people. Well, I can't say people because I don't know who else he facilitates, but he's facilitated the parental alienation by not doing his duty. And when he knew that
Ms Applegate
asked for 21 days, and
Ms Applegate
went to him, and I have that email chain because he contacted me right away, and he was given the notice of application, my notice of application, that I wanted to amend my access time, and I told him, and I've got recorded messages telling him why it's so imperative that I stay in my kids' lives, and that every minute I'm not in my kids' lives is a danger to my children. And I'll just refer to that as one of the reasons we went to court before. The tape recording of JS and what happened there. So, and he was made completely 100% aware. He knows. I told him about the transcript of JS, the conversation with Ms
Applegate
self talking about JS and what happened 30 years ago. He was made fully aware of that, and still the runaround, and we're talking over twice as much time. Well, he's got 14 days. I know I keep saying 21. That's for other court matters. He's actually only had 14 days, and he's up to like 2 months' time now. And I get a call on Sunday here, which is, I should mark it. It is Sunday, July 12th, 2015, and I get a call from Andrew Lau out of the blue, not wanting to tell me why he didn't respond to my notice of family civil claim regarding my want for change of access within that 14 days he had by law. And he is now giving me a call on Sunday, getting all mad at me, and trying to play games with me, and trying to get me to say that I want to extend my time when I don't. He had till the 16th, and he didn't comply in the 14 days to respond. And it's just, again, it's just over and over. It's just absolute abuse of people in the court system who are not lawyers. If you're not a lawyer, you will be abused like no one's business. And these guys are just, they're accountable to no one. It's a law society. I will be writing something about him to the law society regarding this, and regarding him going to the principal and asking him to write the child apprehension letter that also was used in court. And he ambushed me with the minimum 8-day requirement, and that almost killed me. And that's no joke. It literally almost killed me. I came as close to death as ever in my life because of that, what he did to me with that phony child abduction letter, and ambushing me in court and presenting to the judge that I was some kind of attempted child abductor. That was just uncalled for, and an absolute just disgrace of the law in Canada. Anyways, it's 4:27 p.m. July 12th, 2015.